have a dream that one day this nation will rise up and live out the true meaning of its creed. We hold these truths to be self-evident that all men are created equal. I have a dream that my 4 little children will one day live in a nation where they are not judged by the color of their skin, but by the content of their character. I have a dream today. These famous words from Dr. Martin Luther King Jr. touched hearts and souls across America. He spoke about an American future where man is not judged by his color, but by his character. Dr. King gave his speech in support of the act proposed in June of 1963, the Civil Rights Act. When President Kennedy sent the act to Congress, opponents objected to various provisions. Supporters like Dr. King marched on Washington in 1963, where he gave his famous speech. After Kennedy's assassination, Lyndon Johnson pushed the new law as a memorial to our fallen president. The plan was successful, and the act was passed in July of 1964. It immediately accomplished most of the activists' major goals and is a hallmark of the American Civil Rights Movement. Today, I want to show how important and influential the Civil Rights Act of 1964 has been to our society since its passage. I will explain the CRA's impact in 3 ways. First, I will explain the climate in which the Civil Rights Act was passed, along with some of the law's defining features. Second, we are going to look at how the act has been applied since its passage, and finally, I'm going to explain why the CRA remains influential today. What we will see is that Dr. King's speech is an important marker for examining the civil rights movement and its continuing impact on Americans. Thomas Sowell, Senior Fellow for the Hoover Institution, defined civil rights in his book, Civil Rights Rhetoric or Reality. Initially, civil rights meant quite simply that all individuals should be treated the same under the law, regardless of their race, religion, sex, or other such social categories. Many supported this common belief in the value behind civil rights. When President Kennedy originally sent the act to Congress, opponents objected to various provisions, such as Title II of the act, which banned discrimination in public accommodations like hotels, restaurants, and theaters. Senator Strom Thurmond argued that the act empowers the national government to tell each citizen who must be allowed to enter upon and use his property without any compensation or due process of law as guaranteed by the Constitution. He believed that the law empowers the government to govern the hiring and firing of private businesses. Senator Hubert Humphrey contended that passing the law ensures that no American would suffer the indignity of refusal of service. After the law's passage, the Supreme Court ruled the law a constitutional exercise of the federal government's power to regulate interstate commerce. Private businesses had to serve anyone and everyone protected by the Civil Rights Act. The Act had 11 titles, each focusing on an area where discrimination may occur. Title VII of the Act banned employment discrimination, and according to the Heritage Foundation, Senator Humphrey, who guided the act through the Senate, assured his colleagues that the law does not require an employer to achieve any kind of racial balance in his workforce by giving preferential treatment to any individual or group. All men would be treated equally, as Dr. King dreamed. If an employer required tests for job applicants and those tests disparately impacted groups, Humphrey declared that to be legal unless it was used for the purpose of discrimination. Employers would not have to validate such tests. Let's see how the CRA has been applied since its passage by examining Senator Humphrey's assurance to the Senate that the law would not require a racially balanced workforce. In 1971, the Civil Rights Act was put to the test by the Supreme Court in Greggs v. Duke Power Company. The court was asked whether a power plant in North Carolina could give an aptitude test to its employees. Chief Justice Warren Burger, along with the court, decided they could not if the test disadvantaged blacks in any way. Burger wrote, "Absence of discriminatory intent does not redeem employment procedures or testing mechanisms that operated as built-in headwinds for minority groups." The newly empowered government can now steer the interactions of private citizens to fight racism. Christopher Caldwell, in his book Age of Entitlement, America Since the 60s, states, "The Griggs decision made clear that the government was now authorized to act against racism even if there was no evidence of any racist intent." In 1978, Alan Bach was rejected multiple times from the University of California, Davis. He appealed his rejection, and it made it to the Supreme Court, which acknowledged that the UC Davis program was discriminatory. Bach was denied because he was white. Justice Lewis Powell stated it was wrong to penalize Bach as a means of compensation for past discrimination. He even admitted that the college's admission policies based on race were wrong, but he okayed UC Davis's program on the basis that infringement of Bach's rights was warranted to fix a society's wrongs. Through a new definition of diversity, race should be allowed as a plus factor for admissions. It only took 14 years for discrimination to be redefined to enforce discrimination. The law was now being used in a manner contrary to its original intention. Apparently, Dr. King's dream didn't apply to Bach because he was the wrong color. Something has definitely shifted in how we are trying to remove discrimination with the Civil Rights Act. But let's see just how much by examining how it's affecting Americans today. Christopher Caldwell notes that civil rights offered new grounds for overruling and overriding legislators and voters on any question that could be cast as a matter of discrimination. That was coming to mean all questions. In January of 2022, New York State published medical treatment guidelines for those eligible to receive COVID-19 drugs. These guidelines include not only comorbidities like cancer or heart disease, but also include ethnicity as an eligibility factor in receiving medical treatments. The Wall Street Journal headline was clear when it said New York's race-based preferential COVID treatments. The guidelines say that social inequalities cause people with a non-white ethnicity to be at an increased risk of severe illness and death from COVID-19. Now, the color of your skin determines whether you can receive medical treatments. And that's not all New York City is doing. In New York, it is considered discrimination to deny someone access to a bathroom based on their gender identity. That means that boys can go into girls' bathrooms and vice versa. This month, the Washington Times reported that the U.S. Department of Agriculture said it would consider discrimination based on sexual orientation and gender identity to be a violation of Title IX. The government intends to withhold federal lunch money from schools that try to prevent transgender athletes from competing in girls' sports. The government says that those failing to comply will be in violation of civil rights laws. Is this what Dr. King's dream meant? Really? Let me be clear. I think racism is wrong, unequivocally. We should not be judged by the color of our skin, but that begs the question, is this a wrong that the Civil Rights Act is best suited to fix? We would all like to have hotels and restaurants that don't do people based on their color or sex, but by requiring that through the power of government, we have unleashed a whole new kind of evil. Schools have race-based quotas to ensure they aren't discriminating. Schools may lose lunch money because the Civil Rights Act is forcing transgenderism into girls' athletics. In New York, who knows who will walk into the bathroom with you? Is this the fulfillment of Dr. King's dream? Clearly, the Civil Rights Act has been a dominating force, unquestionably influential and impactful on Americans since its passage, but I don't think that we can say that the America Dr. King had dreamed of is the one we live in today under the Civil Rights Act. The answer to how we can solve racism and achieve Dr. King's dream is not in Washington, and it's not in the Civil Rights Act. The answer is right here in this room. The answer is you and me. We are the ones who can end racism. We are the ones who will end discrimination. We are the ones who will make this dream come true today. Thank you.